Thank you for tuning in to our YouTube channel, African Dignity. Here is another lesson for today. This lesson will deal with topic number 6 of your course outline, right, with the legal practice A. And this topic deals with a very sensitive issue that the police have not yet been trained to master in terms of our new constitution, because you'll find that some of the police were employed way before 1996 when this constitution came into effect. You will forgive me about the quality of the lightning. We've just had load shedding, but it is important for you guys to get this lesson. We are dealing with topic number 6 of your course outline, right? That deals with the powers of the police to search and seize articles in your possession, right? In order to attract your attention, let me tell you a story. When I was about at a very tender age, right? I think I was still in standard 1 or standard 2, say standard 1. I happened to be in a place called Pietermaritzburg, and my duty there was to help my mother to make a living. And what we were doing was illicit, right? Which means I was exposed to crime at a very tender age. And my mother would ask me to sell a prohibited concoction of what was called imbamba ishimayane, or petiviki if you like. So I would sell that to the people who were working for a construction company called Roberts Construction in Pietermaritzburg. They were building a suburb called Grange, the Grange in Pietermaritzburg. It's near Alexander Road. It's next to Slangspoort, and we were staying in the shacks in Slangspoort. So we will just cross the small stream, and there was a forest then, but that forest has been removed and there are houses built there. And we will hide in that forest and sell this concoction to the workers. So they will come and sell. We'd use a 500 milliliter 500 milliliter container. Sometimes it will be a jam container, or sometimes it's a 1 kg and also a 2 kg, the jam container, apricot jam, all those jams. So we will use those, just open them and use it to determine whether the first one, 500 milliliter, will be how much? Will be 5 cents, and the 1 milliliter will be 1,000 milliliters, which is equivalent to 1 kg, will be 10 cents, and the 2,000 milliliters will be 20 cents. So I would sell that. It was illicit, and police would come, and my mother would run away, and I was told not to run away, to stand my ground and claim possession of this concoction. And the police would come in their shorts, with their blue eyes. And I'll tell you, I was very scared of the blue eyes, but my mother would say, no, don't be scared. Just stand your ground and tell them that this is your stuff and you are selling it. Because you are young, they are not going to arrest you. But guess what? I would be taken with my staff, with the money that they found on me, to a place called Loopstraat police station in Pietermaritzburg. Loop Street, if you like. I'll be taken there and not detained in the police cells, but be kept at the police station and be told not to move until my mother comes and look for me. When she comes, then they will grab her and arrest her. So that was our daily life. And so what would the police do? They will come and destroy these containers, and I was very annoyed with the fact of them destroying it. I wouldn't mind them spilling the concoction, but when they destroyed the tins, that's where I was offended, because it was my duty to go to a place called in Pietermaritzburg. There was a firm called Willow Tin, where they made cooking oil. So I'd go and get these 20-liter containers where we would do the concoction. So they will come and destroy that, seize it, and maybe seize it as an exhibit so that they can be able to take it to court on the following day, so that my mother would be charged for dealing in prohibited concoction like sishimine, like I've said. So police would seize. Sometimes they will come to our house. They will take me and say, show us your house, and I will take them to our shack at Slangspoort and show them, and they will find my mother there. They will search for some more, and they would get some more of this substance, of this concoction, and take it away and take my mother with them, and then she will go to court and maybe given a fine. In those days, the fine would be 20 rands, 10 rands for being in possession of this concoction. That was the life then. Now, let us deal, now that I've got your attention because you like gossip mongering. Now let's come to our topic. Or before I get there, I told you about ex parte application. So when the time came for me to be admitted as an advocate, I had to go and do an ex parte application in Pietermaritzburg Court before judges, Madam Justice Baltin and Madam Justice Mukhohlwa and acting judge Potgieter. Right? That was acting justice Potgieter. So those are the people who admitted me. So when I made that ex parte application, I had to divulge everything, including the fact that I was used by my mother to sell those prohibited concoctions. This is what you need to do when you are admitted. If you have ever been involved in any illicit dealings, you need to divulge that, because one day your enemies will come and say, how was he admitted when we know that he has been selling drugs, selling cocaine and stuff in his location? So you need to divulge that so that the court will decide whether they admit you or not, because you've got to be a fit and proper person to be admitted as an attorney or advocate in my case. Right. Okay, now let us now come to our topic. I said it's topic number 6 of your course outline. Right, so we're going to deal with it. I will first give you a scenario, right? A scenario where a certain captain of the police force is an investigating officer, right? This captain has got information of a murder case, right? And he finds that your vehicle was seen in the vicinity while this murder was being committed, and he's got information that you were seen near the scene at the time of the incident. And then we call him Captain B. Captain B decides to follow up on the information and visit your home address, right? And also look at the registered owner of the vehicle that you were driving and find that it was you. Now, the question will then arise: discuss the powers of Captain B in terms of sections 26, 27 of the Criminal Procedure Act when he arrives at your home? What are his powers? That will be the question. Okay? And then the second part of the question will be, you admit that you were in that vicinity when the murder took place. However, you decide not to be cooperative, right? And you inform Captain B that you do not want to get involved in this matter. You are scared that the people who committed the murder might come and kill you as well. So you refuse to make any statement, and although Captain B is convinced that you have information that may assist him in solving the case. Now the question is, what steps that Captain B can take to obtain information from you if you refuse to give this crucial information that will lead to the arrest? You are not involved. You are not involved, and you but you are this crucial witness to crack the case, or to make sure that people are convicted, because there is information that you know who the people who committed this murder, but because you are scared for your life. Now, answer that question. What are your rights, and how does Captain B will be able? How will he be able to solve this problem and make sure that you are brought before court? That is the answer that you need to advise in this case, or discuss in this case, right? Okay. When answering that question, we will start by saying Section 26 and Section 27 of the Criminal Procedure Act, right? It essentially governs the behavior of the member of the police when when they are confronted with a situation where a possible witness refuses to cooperate, right? And first of all, we know that even entering the premises might be a problem, right? Although Section 27 and Section 26 and Section 26 and also Section 27 of the Criminal Procedure essentially governs the behavior of members of the police who enters the premises in order to conduct an interrogation. Interrogation, I don't like the word interrogation. It's just an investigation, still an investigation, not interrogation, because if you use the word interrogation, is what was used during our times before this democracy, during apartheid times. We were subjected to something called interrogation. Interrogation was very terrible. Sometimes you'll be hanged up behind your back, and somebody will just put a sack over your head, just an ordinary sack, the sack for storing meals. They'll just put that sack and then put water. It's a wet sack. Then start putting water and tie the sack that you are unable to breathe. Sometimes they'll put a tube. They'll take a tube and put it around your mouth and nose so that you are unable to breathe, with your hands tied at the back. That was called interrogation until you speak the truth. So with the advent of the Constitution, that is no longer allowed. Section 14 of the Constitution recognizes the right to privacy of every individual, which include the right not to have all of the following contravened. Things like your privacy to your person or home, privacy not to have your property searched, a right not to have their possession seized. Nobody can take anything from you unless it is done by way of law of general application, right? The privacy of their communications. So if, for instance, your phone is a private property and that the information that we have in your phone is protected by Section 14 of the Constitution, in that nobody can just come and say, let us see who you've been calling. There is a murder and you're suspected to be part of this murder. So we want to see, because we have arrested the murderer and there's suspicion that your husband who was killed at your direction, you were the one who hired the assassins to come and assassinate your husband. So they will arrest this person, take their phone, and look at the numbers that called. If your number is part of that, then you will be a suspect to say, what dealings do you have with this murderer? How long have you known him? How do you know him? And then they will start connecting you with this person, and ultimately you will be charged for conspiracy to commit murder, and on conviction you will be sentenced to exactly the same or even worse than the actual hitman. So those are the rights that one has to take into cognizance when the policeman comes to your house for whatever reason, if they suspect that a crime has been committed and you are involved, right? So you must look at Section 26 and also look at the authorities, that is now case law, that supports Section 26 and Section 27. However, there may be instances in which the interest of justice necessitate the infringement of these rights. So you've got these rights in terms of Section 14, but sometimes some rights are limited in terms of Section 36 of the Constitution. So we know that those rights can be limited, right? Section 26 of the Criminal Procedure Act authorizes a police official in the course of their investigation of an offense or alleged offense to enter such premises without a search warrant for the purposes of interrogation such person and obtaining a statement from the person. So police, in terms of Section 26, police have a right to enter your house, search your house without a search warrant. Because what is important is that if a policeman suspects that you have mandrakes in your house or you have a murder weapon in your house, and they are sure that you have, they can go to a court and apply for a warrant of arrest, right? You get a warrant of arrest because you believe that there is evidence in somebody's house, in a suspect's house, that you want to get hold of before it is hidden. So Section 26 allows that. But now the problem is Section 14 of the Constitution doesn't allow it. So now there is a conflict. But we all know that when there's a conflict, the Constitution will take precedent. So the Constitution will overrule what that section says. But also it now depends on the court's attitude as to whether they should allow that evidence or not. But also there is also in that section, if evidence is obtained by way of threats or deceit or misrepresentation, that evidence is obtained illegally, then I want you to make it to make your determination as whether evidence that has been obtained illegally can be admitted as evidence in court. Okay, we will deal with that when we come to class on Friday. Right, the police official in these circumstances must now reasonable suspect that a person who may furnish information with regard to any such offense is in those premises. So there must be that belief, and depending on the informers that he has. If the informer says, I know that the stolen car is in this suspect's garage, I've seen them parking it in and locking the garage, I know for sure it's there, and I was standing and watching all the movements. I am sure that the car has not moved. So as a policeman, you are sure that a stolen vehicle is in that house. You do not need to run to a police station, to a court of law to go and apply for a warrant of a search warrant in this case. What you will do, you will just go into that house without a search warrant and remove the vehicle and arrest whoever is in those premises until you establish as to who brought it and who brought the vehicle, who is in the possessions of that vehicle. Okay, now let's come to section 27. Section 27 of the Criminal Procedure provides for the situation where the occupier of the dwelling refuses the police entry into his premises, which may also hamper the police investigation. Now, section 27, subsection 1 of the Criminal Procedure provides that a police officer who may lawfully enter any premises under section 26 may use such force as may be reasonable necessary to overcome any resistance against such entry, including the breaking of any door or window of such premises. So section 27 allows the police to even break into your house in order to get into that vehicle. Say the vehicle is in the garage and the garage is locked. Police have a right to take any object, break the garage, and get the vehicle out of the house so that it can be used as evidence in court against your client. Right. And there is also a further proviso to this section. However, that a police officer may not enter any private dwelling without the consent of the occupier thereof. That is now the conflict. You can't just go and enter in any house without the consent of the, unless you know for sure that a crime has been committed or an evidence that will lead to the conviction of the said person is in these premises. Then that's where section 27 will. So it's a very tight rope to tread on. So the policeman has to make sure that he's got the correct information for them to do what? To enter those premises, right? Section 27 provides for the situation where the occupier of the dwelling refuses the police entry onto the premises, which may also hamper the police investigation. And also section 27 subsection 1 provides that police official who may lawfully enter any premises under section 26 may use such force as may be reasonable necessary to overcome any resistance against such entry, including the breaking of the window of the premises. Right. And then adding on that proviso, of section 27, right? The subsection provides further that such a police official shall first audibly demand admission. The policeman cannot just go there and not say anything, just break your house. They must demand entry, right? And it must be audible, clear and audible. Demand that premises must be open, and also state the purpose of which he seeks to enter such premises. You must say, I will suspect that there is a vehicle that is kept in this house and that vehicle is stolen, so we want to search your house. Say that audibly and without any doubt. Just say it clearly so that everybody, the person concerned, understand what is the purpose. Okay, for the purpose of interpreting section 27 subsection 1, it is worthwhile to note that Criminal Procedure Act in subsection 1 provides a wide definition of the word premises. The result thereof is that premises refers not only to land or buildings, but also to vehicles, ships, and aircraft. They are regarded as premises. If somebody is at the airport and is about to do what? To fly or to flee justice and go to another country, and is in that, the police have a right to stop that aircraft, regardless of the schedule, time schedule, and everything. They have the right to stop that aircraft, to say, stop the aircraft because we believe that so and so, who is a fugitive from the law, is in that aircraft, and we want to search it with a view of arresting him so that he can stand trial. You can't do that without a warrant, using the proviso of section 26 and section 27. Now, let us come to another very important section, which is section 205, right? Section 205, to make it very simple, because if I talk about statements, maybe you might be confused. Section 205 is where police go to a court of law and apply, right? Because you have to do this. As an attorney, you must be very wary or be vigilant and make sure that you find out, you get an order, because there must be an order that says, yes, you can go and interrogate, or you can go and search, or you can go and get information using the provisions of section 205 of what? Of the Criminal Procedure Act. That section is also used to say, for instance, you want to get information from your cell phone to see if you had communications with the killer. Then section 205 will kick in. Then the police will have a right to go and confiscate your phone and get what is called the IEA number, something like that. You go and get that number and give it to Vodacom or MTN so that they can be able to give to the police messages, especially if people communicate with WhatsApp. That message stays there forever. It doesn't go anywhere, even if you use what was called disappearing messages. But for the purposes of section 2, that message will stay there. It's recorded. In fact, it's recorded at MTN or Vodacom. Then they will know that you contacted the killer at what times. Sometimes if you send a WhatsApp, the WhatsApp will be there. Say he will be wearing a check shirt, a blue check shirt, and sitting in his office and busy recording a video. Then you can just go and shoot him. They will get that information, and then your client will be implicated as having been part of the conspiracy. Right. Section 2, let's talk about Section 205. Section 205 is specifically designed to compel a potential witness, right, to reveal his knowledge of the alleged crime, which he refuses to disclose to the police. So now he'll be forced. You don't want to reveal this knowledge? Here is an order of the court. And if you refuse, what happens to you? You are in contempt of court, because this is a court order that says reveal the knowledge. You say somebody gave information to the police that your car was seen during the time when the two taxi bosses were killed. You are then obliged by this court order to tell us what was the registration number of the vehicle that came and opened fire on the two taxi bosses. How many people were there? And there's information that you know one of them. You must tell the police who that person is, and also where he can be located. That is now the address, right? Such person may, upon request by the Director of Public Prosecution or prosecutor, be compelled to appear for examination before a DPP or public prosecutor of any other judge or magistrate. So you will be subpoenaed to come and appear before the DPP, magistrate, and or judge, to be interrogated, to be interviewed, to be cross-examined as to the knowledge that you were there. Are you refusing? And that also makes you now, if you continue to refuse, it makes you what? Being complicit to the commission of that crime. And as an attorney, you have a duty to advise your client that you were there. There's evidence, even your phone, because they've done Section 205. So your phone will say you were in that area at the time when the murder was committed. So the Vodacom or MTN towers cannot lie. They will say this particular phone, your phone, was at Langezwe during the time, because it was using a certain tower that is at Langezwe. So you will be done what? You will be part of, or you will have to disclose now, because everything is there and they can see that you were part of that. Right. And then the provisions may only find application after authorization by a judge, a regional court magistrate, or a magistrate upon the request of the DPP. The DPP is Director of Public Prosecution, or just an ordinary public prosecutor. If, however, such person furnishes that information to the satisfaction of the DPP or public prosecutor concerned prior to the date or on which he is required to appear before the judicial official mentioned above, he shall be under no further obligations to appear before such judicial officials. Right. That is now in terms of Section 205, subsection 1. So if that permission has been obtained and you freely give information to the prosecutor and he is satisfied that the information that we are giving them is genuine, then there will be no need for you to appear before court, to be interrogated or to be cross-examined, right? Such examination can be conducted privately at any place designated by the judicial official. That is now in terms of Section 205, subsection 3. And it doesn't need to be held in a court of law, so it can be done in a private place determined by the DPP, right? The witness is entitled to legal representation. That was the issue in the case of Smith versus Van Nerkerk. The citation is 1976, volume 4, SA at page 304, right? And also In the Hayman's case, that is now in 1966, volume 4, SA at page 598. This was a matter which was held in the appeals court, so it carries more weight that you've got to be represented when this exercise is being carried out. Otherwise, if you are not represented, you may say they went and got this order, but they forgot to advise me that I have a right to be represented by an attorney, because it's possible that you might find yourself implicating yourself. So it is important. You also find your client implicating himself. If he was never given that choice of getting a legal representative, you can now protest and say that whole exercise was irregular. So the conclusion is that Captain B may successfully invoke the provisions of Section 205 in order to do what? In order to force you to make a statement to that effect. So you must read Section 205, and I hope everybody understand the implications of Section 205 of the Criminal Procedure Act. I hope everybody understands. And I want us to have maybe a test or an examination to discuss this as I've just discussed it, because it falls under topic number 6 of your course outline. Please read it or listen to this tuition over and over again until you understand. Also add those cases that I've given, Faneker case, right? And because it's an appeals court case, use that. Thank you.